You may have noticed I'm not Matthias. Unfortunately, he has taken ill and he was unable to fly to London, so they asked me to sit in and be your chair for the day, so please bear with me. I will try my best to navigate you through the day. My name is Joanna Emery, and I'm the head of Pure Ideas. So welcome to the second edition of the Future Tech IP Summit here at Etc. Venues in St. Paul's. Let's start with a simple question. What is a patent? Of course, as we all know, a patent is a legal right, typically granted by a country's patent office that gives an inventor an exclusive right to control and earn money from his or her invention for a certain period of time. As you know, patents go back centuries and have been used to motivate behavior and reward innovation in countries all over the world. In the time of European explorers, for example, the English monarchs wanted to promote the exploration of the New World. If an explorer brought back a new or exotic item, spices, etc., the explorer would be given an exclusive right to sell the item back home for a specified period of time. That was called a letter's patent. In the US and other common law jurisdictions, when a patent issues, it's still called a letter's patent. So for centuries, patents and other forms of IPRs have been an important way to incent innovation. Today, we may not be promoting exploration or geographic frontiers, but we certainly are promoting exploration of technical and scientific frontiers. Creating and inventing takes a lot of time, effort, trial and error, and risk-taking, and sometimes all of the investment goes nowhere. But sometimes all that work leads to something new and novel and useful, which creates an opportunity to secure a patent and the opportunity to generate value from all that work. The invention is then brought to market, generating funds. The proceeds are then reinvested, and then the cycle then continues. Today's technology and business environments can easily be characterized as breathtaking. We experience new business models enabled through technological innovations, such as self-driving cars. As we see incumbent market leaders diminish in their importance as new market entrants come in, disrupt traditional go-to markets. Think fintech and blockchain, DLT-enabled businesses. And we continue to see the dynamic pace at which technological advances shape our daily lives and push the boundaries for what's possible. For example, artificial intelligence or biotech. While the future is tomorrow and we first need to get there, the now is exciting. It is exciting for consumers who enjoy new ways of interacting with their environments and with technologies. It is exciting for businesses who shape the way we think about the world and who create value for the shareholders. And it is exciting for us here in the room who deal with IP and at the intersection of innovation and markets. This conference brings together experts and thought leaders from the industry, academia, and legal professions to discuss and share their unique viewpoints with regards to IP. I encourage you to actively participate in today's conference and challenge your own views. I trust you will get a chance to see many of your colleagues and friends and to meet new people today and tomorrow. Please enjoy the conference. With that, I am honored to introduce to you the first speaker for today, Mr. Luke Ham, the CEO of GovGrant. Thank you.
Thank you very much. Good morning, everyone. Delighted to be here. I am busy, and I have zero interest in big legal fees. I don't actually get sometimes what I can do and when I should do it. And quite frankly, I don't have the time to think about it. That is the common view of most SMEs that we meet. At the start of a project, they're so enthusiastic to get the job done, to bring something to market, that the idea of putting funds aside when they really should to think about their IP strategy is almost non-existent. Do they really want to take that risk bigger when they don't know if it's going to work or not? And we need to change the narrative. The UK is just about to become far more competitive in its global landscape. And if we don't think about what we look like from an IP perspective and from an intangible asset perspective, we are at real risk of falling behind. Tomorrow marks one of the most significant votes in our history. And we've heard plenty about the movement of goods, but we've heard very little about the knowledge exchange and what that will look like after next May. I find it quite alarming, in fact, that as we aspire to become one of the global leaders, and we are, as we all know, a nation of inventors, that this hasn't become a big aspect of the debates, a big part of why people are thinking how we should do it, what should we do, and having a real knowledge of what does that look like for us as we move forward. The agenda this week for London IP Week is excellent. It focuses on the industries that are on the cutting edge of what happens next. But there are so many industries that exist currently that make up the vast majority of our workforce and our ideas and our inventions that aren't present. Manufacturing. We see a number of manufacturing clients, and they continually are improving what they do and how they do it. But when you speak to them about, so what does that mean? What are you doing about your IP? They struggle. They really think about, well, what is the next step? How do I create it as part of my rhythm, particularly in the SME space? It's in our gift to shape the agenda with government. We spend a lot of our time speaking to government around what they should do to continue to invest in innovation in the UK, and how do they take IP far more seriously at the SME level. And we are in control of that story. And we as a community of professionals and experts need to really grab that subject and be very confident in what we say and how we say it to many, many audiences. I think the other thing to point out is there are plenty of well-backed technologies coming through. And the financial impact of when those big backers are there and the funds are there and they know they're taking that risk, they are far more willing to think about their IP strategy from day one when they should think about it. But the smaller guys don't. And it's a real shame. Why should that small, still potentially fantastic idea be ruled out of the game? Why should it be an elitist sport where only the biggest money, the biggest players can really take control of those ideas? Because if I invest and I take that risk to create those IP assets, and then I just get steamrolled. Someone wants to come along with bigger pockets, with a bigger legal team, and I don't stand a chance in defending what I've created. That has to be addressed. And that's not just a subject for us as a community, but that's a subject that government really needs to think about. They need to think about how do you protect those assets that are created on UK shores. I will declare my hand now. I'm not really an IP person. I'm a commercial person. I speak to my clients and I want to understand what do they want, how do we do it, and how do we get them there quickly. And that's probably my biggest asset here today. I don't come tainted with a history of all of the complexities and all of the wonderful academia that surrounds the subject of intellectual property. All I come with is a narrative that my clients tell me, and what they tell us day in, day out is it's just not top of the list. A common concern is what's the point of protecting IP? And it's a real concern. We work with a number of clients. We work with over 1,000 clients on their research and development tax credits. They're doing research and development. We've identified enough innovative, excellent work that makes them tick the box to be able to get a big check from the government. But they don't want to take that story forward into thinking about what their intellectual property looks like. For me, there has to be a fundamental issue there. In numbers, there were over 42,000 research and development tax credit claims last year. Patent Box, which was the government's idea to put alongside to really think about, if you're doing this, you should also benefit from the patent elements and the patent benefit. Less than 1,000 claims made. And if you knock out the big players, only £45 million worth of support versus the R&D support of over 3.8 billion annually. there is a disconnect, and we need to acknowledge it. And we need to think about why do SMEs in particular, not bring those 2 points together and recognising they do R&D, plenty of R&D, year in, year out, and turn that into asset. We also need to expand the conversation and then take an interest into other strategies, not just protection, but the language in which we use. Often, with all due respect, this becomes a very academic subject, and it becomes a difficult conversation to have with many clients because they become intimidated. Many of our clients, many SMEs, as most of you will probably agree, want to get to the subject quickly. They are busy people running their business. And we may think it's a really encouraging and great thing to talk about how wonderful and how complex things can be. That does not help. That is a barrier. That's a barrier to engagement, and that's a barrier to the SME community engaging with us as a community of professional advisors. An example I'll use is the plastics industry. We work with the British Plastics Federation, and they are at a real trouble point, as we will all know. Every single plastics company we have as a client are thinking about, how do I make this sustainable? Every single one. How do I make it sustainable? Now, when we go and speak to them, the question is, are you trying to solve a problem, or are you thinking about what invention you're going to create? And guess what? It's never about the invention. It's about the problem factor. It's about overcoming something they have to deal with now. It's not about, how do I run with this future? How can I license it? Because they're established businesses. They're doing something, and they need to address it. The new startups have got a luxury, again, back to my point of if they're well-funded. A new, well-funded, sustainable plastics company will have IP front and centre of their thinking, front and centre of their budget. But the established players who have got teams of fantastic people, fantastic engineers, will not take that thread. It will fall away, and we won't pick up on those assets. How do we change that? How do we empower business owners to understand when the IP bell should ring in the same way as other considerations? If I'm growing my business, I think, what's the premises looking like? How many people do I need? What's my IT infrastructure? Why is IP not on that list? Why do we not just tick it through to think, this is the next stage, this is what I'm going to do? And it leads to a fundamental question. What do SMEs play for? Most will, if they're owner managed businesses, will be thinking about, what does my exit look like? Is this my business? Do I just want to keep on going? And what does it look like? Does IP make me look better in the shop window? Does it help me make a better investment decision? Do I look more impressive than a competitor? But actually having that conversation about where am I going with my business doesn't really happen. And it's quite difficult to then think about, well, if you need to think about what you look like to the outside world, and you haven't thought about, what do I do next? What does my exit look like? It's quite a difficult bridge to grow. But this is the opportunity. For us as advisors, this is a real opportunity to think about how IP becomes that driver of that next decision. Because the biggest thing that we know from almost all businesses is that they want to know, what's in it for me? What am I going to get at the end of this? What does it look like? And if we can make that IP subject part of the exit conversation, it's a healthy place to be. A common denominator as an external party, as investors, when we work with the investment community, and it's a phrase that most of the room will be aware of, is what's the freedom to operate? And now most, if I've got a great idea, I come to very good, excellent patent attorneys and say, I've got this idea, let me cover the field. I want to make sure no one comes anywhere near me. Let's get going. Is that right? And that's a question I ask the room to think about for the next 2 days. Is that right? To think about, I need to cover everything. I need no one else to play anywhere near my field. Or do you start the conversation differently? Do you start with, what's the tangible benefit I can achieve quickly? Do I have to find a blade of grass to at least get the person on the field thinking about their IP? We see a mixture of clients. Some that are very much focused on the academic challenge, and IP protection is a badge that's a valuable asset to have. However, they tend to sometimes lack the commercial drive. So that link between who the inventor is and who the business driver is also needs to come together. Identifying those people to think together is critical as management teams structure forward. And then again, back to the investor point. If I'm the investor, do I like the idea but hate the management? Can I kick the management out and take the idea? And that's where, actually, there is a real opportunity for the market to think about, how do we drive that difference? How do we think about people, where they want to play and how they want to play? And is it relevant to think about the field, or is it to think about the blade of grass? Understanding is also a key challenge that we need to think about, how do we address. It's a common aspect that actually thinking about what strategies I can deploy, is it just a patent or actually trademark, what do I do? And engaging that in an accessible way, back to the language in which we use, that engages with that SME community. It needs to think about, how do I get this guy thinking, how do I get this business thinking in a way that's constructive? That it's in a way that encourages the creation of those assets, not just, I'll move on to it next time, and then they've missed the opportunity. A real example we had quite recently was a microwave manufacturer. Been doing it since he was 16. He's in his more senior years now, and worked very successfully with a big company called Panasonic. And he'd come up with this fantastic new liner, never been before seen in the world of microwaves. And as we were talking to this chap, turns out that this large client, Panasonic, were just about to send 4 delegates over from Japan to see what's going on. And we said to this client, so, you know, what's in place? NDAs, what's going on? Nothing. We've had a fantastic relationship for the past 30 years. They won't hurt me. So we sat there and went, surely that level, and I mean it respectfully, that level of ignorance doesn't exist commonly. But it does, because I'm the inventor. I'm the inventor, and this is my business, and I want to make sure the world knows how great I've just revolutionised something that's happened. So I want to get it out there. And I don't go through those DD steps of thinking about, am I ready to go to market? Am I ready to show the world what I've created without hurting myself? We may not like this phrase, but particularly for the SME community, money talks. And the idea that actually we can keep getting a client to invest without seeing a return is short-sighted. It doesn't help. We need to then think about what tangible benefits exist. I mentioned earlier patent box, and we've worked with a number of clients who would not, and we try and work with our clients to think about what does their IP strategy look like. And as that struggle continues sometimes, we go down to the what's in it for me question. And we almost avoid it sometimes as a group of professionals, where we don't want to get to the nuts and bolts of asking the client, what's in it for me? Because it's sometimes quite difficult. Well, you know, we go into the phrase of, it depends. Depends how we go. I don't really know how much it's going to cost you. Let's just run it a little while. Doesn't feel right for an SME. They want to know what's in it for me and what do I get quickly. And the patent box, if as a community and if we can understand how we engage with clients and with government, how we improve that facility, it's a real tangible benefit. And we have the example, I mentioned the R&D tax scheme earlier. That's a genuine example of when that kind of system works. If we look back when the scheme was launched, not big take-up. No one really was going for it. And then there was a real shift that the understanding of what is R&D shifted, and claims have gone up through the roof. And you wonder, that's a big investment for UK government, 3.8 billion a year, whew, big checks. But for that 3.8 billion, for every pound invested, results in £1.80 to £2.40 return to gross domestic product. Now that sounds like a relatively good investment for me. And if we can think about how we then engage Patent Box in the same way, we've got a real win. I'm going to leave you now with two questions that I would think about over the next 2 days in a really practical sense. And the conversations and the agenda will take plenty, where are we going and what's the future? Two questions I would leave you with. If it were my business, can I see the value for now, not just long term? Can I see it for now? And then the second is, as a community, how do we change the narrative to better engage with SMEs? Because if we can get that right, we really will stand in good stead, regardless of where the vote goes tomorrow. Thank you ever so much for your time. Please enjoy the next 2 days, and happy to take questions over the next 2 days. Thanks ever so much.
Thank you, Luke, for some thought-provoking questions and making us think about IP and setting up the 2 days where we're going to be hopefully answering some of these questions, or maybe even asking more questions so that people start thinking about what their strategy is, what their IP should be. Our next panel discussion will be looking at the importance of IP for tech startups and what their exposure is to patent or not to patent, but also looking at other forms of IP and hopefully getting people to start thinking about how they should be moving forward. So with that, I will introduce the panel chair, Peter Waggett, who is Director of Emerging Technology at IBM, and he will start the discussion.
Okay. Thank you very much. As I said, the aim is to try and look at what the value of IP is to tech startups. Now, I work for IBM. We're currently the largest patent creator in the US patent history for the last 25 years. But at one time, we were a tech startup. Now, 100 years ago, international business machines meant weights and measures and time recording systems. I'd probably argue that if we were still just focusing on weights and measures and time recording systems, we wouldn't be in the position we are today. So, once you start up, you do then constantly have to keep reinventing yourself. But what I've managed to do, and I say I'm honoured to get asked to do this, is to introduce the panel of speakers we've got to give you their insights onto this aspect. So, if I can ask them to come up and take their places, and we'll start off. So the plan is that we're going to get Alex, who's going to give us a sort of like a scene-setting introduction to the area. And then each of the speakers will just give a few minutes introduction, including Joanna, who's graciously agreed to sit on the panel as well. So start off with Alex, if you can just give us the brief introduction then.
So I'm Alex Bone. I'm a partner with A. Thornton & Co. with offices not too far away from here. I'm a patent attorney, so I'm obviously biased towards the IP is important side of this debate. My background is I started off in private practice. I had a quick 7-year sojourn through in-house at a pharmaceutical company doing medical devices, and I'm now back in private practice. 2 seconds. Is that better? That sounds better. Yeah. Perfect.
And again.
I won't go through that again because you don't want to hear my life history again. So I wasn't sure what the level of the audience was, who knew what, so I thought we'd just start with a really basic run through of what is IP. We've got a question of is IP important, or what is the importance of, and it's probably a sensible thing to just set the playing field out. What is IP? We've heard what patents are. They're an exclusive right, or a right to prevent third parties from playing in your technological space. And patents protect technical inventions, so they protect the way things work. You've then got designs, registered designs, which protect the way things look. So they protect the aesthetic creation, the effort you go into making your product look pretty. And that could be a physical object, the external shape, or it could be an icon on a computer screen. You've also got trademarks, which protects your brand, your name, and that can be a word or a logo. So those are the three core IP rights that are registrable and that most people have heard of. Beyond that, you've got the unregistered rights, like unregistered designs and copyright. These are automatic rights that protect you from somebody copying your hard work. And then beyond that again, you've got confidential information and trade secrets, which are things that your business value as useful, tangible assets for you, or intangible assets for you, but that you don't want to tell anybody else about. So there's a whole slew of IP rights there that you can exploit as a company, but you have to, A, understand that these things exist, that you're creating them, and then once you've understood you're creating them, what do you do with them? So as we know, we can register these things, we can file for patent applications, we can file trademark applications, we can keep them secret, but why are we doing all these things? What benefit does that have? What's the strategy behind it? And we've heard about exits. So is your exit 2 years down the line, I want to sell the company? And if you're going to sell the company, what are you going to sell? You've probably not been in the marketplace for that long. You've got an idea, but what are you selling? You're probably selling a lot of IP. And if your investor or your buyer is looking at your IP and looking at your company and thinking, how much is this worth? What am I actually buying here? If they're simply buying an idea, the valuation may not be quite as high as if they're buying an idea which is actually protected by some IP, a patent, a trademark. Of course, you might not want to sell. You might be thinking, this is my business, I'm going to be working in this forever, we're just going to grow the business, in which case trade secrets might be the way to go. If you are selling a product that your competitors cannot reverse engineer, or the innovation behind which they cannot reverse engineer. So if you've got a new process for manufacturing a renewable plastic, for example, and your competitor can't see from the final product how you've made that plastic, that could be a really valuable trade secret for you. You might want to never disclose that to anybody. And obviously that is one of the deals you do with the government when you file a patent application. You disclose how you've made your clever plastic. You disclose it to the world in return for your 20-year monopoly, assuming you get your patent granted. So you've got a strategy and you've got some considerations behind that, but where does an IP advisor fit and sit behind all that? Most SMEs and startups will have accountants to advise on finances. They'll have an IT consultant to set up the IT infrastructure in their office and set up their networks. But the question is, why do we not have an IP advisor on the panel or on the discussion points early doors? Why are they not thinking about IP from the outset? Things like patents and registered designs have to be filed before the product hits the market, before the idea is disclosed. And if you wait too long, or if you wait until after you've disclosed it, you've lost your right to file that patent application, or at least you've lost the right to get a valid protection for that invention. So it would make sense for SMEs and startups to have that initial conversation with an IP advisor on day one, and that IP advisor's role should be, hopefully, to take the commercial input from the company, find out how what they're trying to achieve. Are they trying to achieve a quick exit? Are they looking for VC funding? And if they're looking for a particular way of doing something, how can you build an IP strategy behind that that helps? Because in general, IP is simply a commercial tool that helps the company do what it wants to do. So with that very quick canter through IP and the strategy behind it.
Thanks so much, Alex. Hand over to Jordan to just give you a perspective on it.
Good morning, everyone. My name is Jordan. I'm founder and CEO of Fan2. Fan2 is an AI-driven company which is revolutionizing how businesses use software as a service. It's my fourth company. We became Dell's first global startup in residence. I've kind of danced with IP throughout my last 20 years in tech. The first time I think I got a taste of IP was during the dot-com boom era when I ended up registering a lot of domain names. This was before there was any kind of IP attached to a domain name. I think the two famous ones were Prada.com and BMWdealer.com. And I learned through that journey that there was definitely a value in IP because both of those companies came chasing after me to take the domain off me. At that stage, there was no actual IP rights behind it, therefore there was nothing that they could do to take it off me. But we decided on a mutual figure, and I realized then the value was going up. Tried again with, I think it was FordDealer.com, and by then the law had changed, and Ford was pretty much coming after me without even probably a fiver on the table to say we're coming after you for the IP. So I realized times were changing. But then it was a pretty good awakening for me, I guess, as a person behind tech and by building companies. I've sold companies where tech and IP has played a role in the value of the company, but then again, I've sold companies where people have not really valued IP. So I guess as a person that's been, building companies and selling those companies for value, it's had its mixed kind of, implications on the sale. And I guess that's something I'll talk a little bit more about today in terms of how does IP factor into what I'm doing today as a company. We are very much a, IP-driven company. I always say that to investors because today it does play a role, I think, compared to 20 years ago. So that hopefully gives you background on myself.
Okay, I hand over to Raj there.
Yeah, hello and good morning. I'm Raj Sark. I'm founder and CEO of Connectin Limited. Connectin, as the name suggests, we are into connectivity solutions, primarily for the Internet of Things space. One of our flagship products, it's called Zupo, which is a wireless smart tag for asset tracking solutions. So it's a piece of hardware and a whole bunch of software and cloud-based services that we provide. My own experience with IP has been probably somewhat different. We have, so 5 years ago when we started the company, we probably made a range of good and bad decisions around IP. Went through a trademark sort of case where we had to rebrand and filed a bunch of patents that has been granted. We are currently working in the area of IoT and AI, and what I'll do is primarily share our own startup experience with IP.
Okay, and Joanne, fine.
As I said, my name's Joanne Emery. I'm the head of Pure Ideas. Pure Ideas is a IP law firm. We do kind of specialize in helping SMEs through their patent journey, their trademark journey, and all their IP, and help them make that decision. My background, I've been doing IP for 25 years. I worked primarily in industry, from FMCGs to Formula One companies to computer companies. So I have a mix, background, going between patenting, trade secrets, and also, working in very highly branded companies where they died by, and lived by their brands. So I, hopefully can bring a unique perspective now being in private practice as to what the pinch points are for my clients on, how they approach their IP and making sure that they do have an IP strategy. So that they're not just going in the dark, because I think it's important to have an IP strategy and know where you're going and what you're trying to achieve. As Alex said, you need to know what your end goal is. If it is to sell, that's fine, but you need to know what that exit looks like. Okay,
so just a little bit about myself. I say Director of Emerging Technology for IBM. My PhD was in rocket science, which for me is great, because if somebody says this isn't rocket science, I can say can't help you. But I've been involved in this emerging tech space for around about 20 years. And one of the key things that I'm always getting across to people is that IBM invents a lot. It's the biggest inventor in US patents. But we don't have all the answers. And so quite often when we get customers coming up to us with with questions that need solutions, we go out to the marketplace and look for ideas that are already there. We do sort of like a make or buy type decision. And quite often, what we find is that startups are those sort of companies that can give us that sort of like leg up in terms of delivering a solution. So for me, one of the key things is trying to understand for a startup is, do they have a strategy about IP? Is a strategy that aligns to what we're trying to do? And if they've got that clear thought, it makes it an awful lot easier to negotiate some kind of deal. The other perspective I've got is that I'm an inventor. I've invented quite a few things. However, you would never trust me to write a patent application. And I say that on the grounds that I've seen what words I've put into a patent attorney, and I've seen the words that come out, and I can't make the connection. But yet I know that what they've said is that much better than what I've been able to put together. So I think there's a role and there's a genuine partnership that needs to happen across startups to large companies, across the technical community into the patent community, and that's a sort of like a real eye-opening moment I had in terms of what's there. So what we wanted to do, having given you a brief background of everybody on the panel, was really turn it over to you guys to come up with questions, and then we'll get the perspective of the panel as they're coming across. So if anybody's got particular questions, if they can raise their hands, and we can kick it off from there. There's a microphone that we can use to get you in case you're shy.
One question.
Yeah,
how do you measure the injunctive value of, say, patents, for example? Because it's very difficult from a business perspective to work out what it's worth. Its deterrent value. You don't see people infringing, for example.
Don't know if you got that. Just how do you see the deterrent value of, say, intellectual property and measure that?
Mm-hmm. Okay. Who would like to kick off with that? John?
So I guess to the first part of what you said there, the intrinsic value to us as a startup probably becomes more real when investors start asking the question of, when you're trying to raise capital, what's the business got? Have you got any users? Have you got any revenues? Have you got any IP? And if the answer to the first two are there's no users and there's no revenue, we've got an idea, then I guess IP becomes quite important at that stage to keep you in the room. I guess in terms of the aspect of protecting the IP at that early stage, at the current time, even with FAN 2, we've got utility patents, we've got trademarks that we know for a fact are being infringed. There's nothing we can do about it in the sense of, have we got the capital to defend it? So we're almost sitting there quietly and just monitoring it. We've told the other infringers that they're on notice, but you have to kind of play that commercial game at that stage in terms of protection and the intrinsic value that's going ahead with it.
Yeah.
Okay.
So I could add on to that, specifically when investors ask the question, do you got revenue, how many users have you got, and have you got IP? So that IP becomes a part of the valuation ultimately the company would get. But on the fundamental question that how do you measure or put a financial number to something as intangible, especially an early stage patent application, which might have a chance of getting granted, might not. Usually there is a whole range of metrics you would look at, like, is this IP actually legally watertight? Does this actually help you gain preferential access to the specific market? What does the competition look like, and how much revenues are they generating? So potentially many years down the line, if you were to sell or even license out the IP, you would look at that number and maybe negotiate a particular royalty figure. But I would say overall, from my experience, when we did our first seed round, this is back in 2013, we agreed to a valuation, and when one of our non-ex finally asked, so why did you guys settle for this particular value of the company, which was adding up, the IP assets, which was quite an important part in the beginning. And we were just, we came up with a value just like this. And we all in the room agreed to it. So that was the value.
Okay. Yeah, thanks for that.
Okay. Just going to add one thing. I guess the deterrent value will also depend on the space in which you're working, because if you've got big corporate looking around, so IBM do those pre-file or those pre-investigation searches, when they start thinking of going into a space, they'll have a look at the area, they'll look at the patent landscape and think, right, do we go here? And if they come up against a solid bit of IP that they look at, they'll have the attorneys look at it and go, that looks like we shouldn't be going in that space. Well, I mean, Novartis always had the view, never infringe a valid patent. So they might take the view it was invalid, so they weren't infringing. But the view is, if you're being a nice, ethical, big corporate, you should not be infringing the small guy, you live or die by your IP, particularly in the pharma industry, you live or die by your IP. So you hope that they respect what looks to be valid IP. And as you say, the downside is if the IP is working and is being a really good keep off the grass sign, you'll never know because no one ever walks on the grass.
There's another perspective as well, which is that sometimes if that valuation's wrong, it can actually kill off a potential industry for quite a while. I did a lot of work in biometrics, so that's recognizing individuals through their physical or sort of like behavioral characteristics. And one of the discussions in this space was that there was a new technology that was invented, which was the iris recognition technology. Now, when that went in, it was a very strong patent. But the valuation that was put on exploiting that patent was very high. And arguably, that slowed up the development of that technology to the extent that some of the other recognition technologies, such as fingerprint and face recognition, actually got better in the meantime and became a viable alternative. So it's one of those things that if you get the valuation wrong, it can either stifle a whole business area, or potentially, if you get it too cheap, then clearly you're missing out in terms of what's on there. So there's a vital part on there. So any other questions we've got coming in? Lady over there.
When thinking about to protect or not protect or keep as a trade secret, one of the major criteria, I think, is whether this invention is detectable, whether it is theoretically enforceable or not. So my question is whether you still see any value of non-detectable patents, patents which even theoretically cannot be enforced because you will never know that somebody used it.
Picking that, I mean, Joanna, that might be something that you've had experience with.
Yeah, I mean, I worked for a Formula One company, and they, lived and died by their trade secrets. It was important that no one knew what was on the car, and sometimes those went on for years and years and years. So they became very specialist in, not patenting. Then they opened up an arm to actually commercialize their technology that was used in F1. And this was something that we looked at all the time is, well, if it's not detectable, should we still patent or should, in another industry, or should we continue to keep it as a trade secret? Now, they were a company that was very good at keeping trade secrets because that was their lifeblood. I think you need to look at, is it viable to keep it a trade secret? If it's not, then, actually, even if it's not detectable, you might want to patent it. You might say, actually, that investment, because as the technologies change, there are sometimes ways of detecting infringement. I worked for a food company, and we were looking at how things were retorted and, trying to figure out, actually, is this being infringed or is this not being infringed? And it was really hard. It wasn't a detectable thing. I mean, we went down to actually buying product and looking at striations on the packaging to say, well, actually, if those marks could only be created if it was done in the way we do it. So there's always, sometimes there is a way, and that's what you need to look at the whole picture. Yes, for the most part, to the general public, it's not detectable. However, can we devise a way to actually figure this out? And there are companies that you can go to as well, independent, where you say, I think they are infringing, and you can get into that. They go in and look as well. So I think it is just a study of your industry. Actually, is it detectable or not? If there is a way that maybe you can, then you would patent, or if keeping it a trade secret just isn't possible, you may then decide to patent, not because you can enforce, but it's a deterrent. And it comes back to the discussion of, the deterrence and infringement, value.
The only thing I could add on to that is very true. It's quite difficult, sometimes impossible at an early stage to kind of know firstly, if your IP is having some legal standing, and if it's detectable in the marketplace, which is what makes even its value quite complicated. where you have to sort of go through a whole legal valuation and do all these things. Ultimately, the value of such an asset really lies in what a customer is willing to pay for. And they do consider all these factors. If I was to be sort of sued, if I could avoid a legal battle, you know, what does it really cost me to do so? And to say between whether to patent, not to patent, whether to keep it a trade secret, a good IP strategy, I would say, is a combination of where you do patent some of the aspect if patentable, and you should keep some of it trade secret. And in fact, I think for a startup as well, a tech startup especially, keeping trade secret at the heart of your IP strategy, I think, is almost as important as looking at patents, trademarks, copyrights, and the other side of IP.
Yeah, I guess I would agree with that. I think it's a combination of both. You know, you need to kind of have something that can act as a deterrent, but then also you need to be, I guess, smart commercially to retain certain knowledge and I guess experience in your technology. In the case of the latter, the deterrent aspect, we had one of the most successful fitness entertainment products in the US. It was an interactive entertainment screen. So while you were working out on a treadmill, for example, you'd look at these screens, and we had a company from China that decided to rip off the design of the product, and the patent actually was a design. It was in the design of the housing. It was helping with the cooling of the unit while this unit was running 12 hours a day. As soon as we, found out that this company was looking to essentially copy the product and supply it to our customers, we, essentially got out there with every, two lawyers, and we basically hit them with cease and desists. We tried to stop shipments of the product coming into the US. This is before understanding 100% if they were actually infringing our rights. We just tried to put them on notice and deter them. And I guess that was a pretty important aspect. Ultimately, it didn't really do much for us, so I'm a little bit tainted, I guess, with IP law. But we tried our best to deter them. It did switch things off for a while, but it's one of the reasons why I got into software and I guess moved away from hardware. So.
Alex?
I just guess one more thing to add is that the value of a patent is not only in its enforceability, there can be marketing value to it. So if you think a customer might pay more for your product because it's patent pending or patented product or made by a patented process, then that may have a commercial value. Whether or not you end up enforcing the patent is almost irrelevant at that point. If you can see a value in the patent pending process or patented process for your marketing, then the patent can be a sensible option.
And I guess flipping the question round, one of my favourite patents that IBM held was that a PC consisted of 3 parts: a display, a processor, and an input-output device, and that was enforceable and clearly visible. And I don't know if maybe some people here are old enough to remember when the Apple came out with the luggable that was basically a box that had the processor and the display in the same cabinet, and that was to get around that IBM patent. So I just thought that was quite a nice patent to actually have him put in place. Another question over there.
Christian Bunky from Melbourne. So this is for Raj and for Jordan. So fast-moving startups in the software space, do you even worry about the UK, or do you go directly to the US with your filings?
I could kick that off. As a UK-based company, I think it's quite important to consider your sort of local market. And if you are, many do advise like go directly to the US because that's where the patents are of like most value. It's quite a litigious sort of ecosystem. So to say, but if you are simply wanting a priority date for a new invention or the inventive step, the strategy we adopted, we did a provisional UK filing. We had 1 whole year to kind of start prototyping, building software systems, and see where else our IP really lies, and decide what to finally protect. So 1 year later, we filed both the UK and then the US as well. And we had a priority date from our UK filing because of the PCT. So it's a worldwide corporation. And this really helped us because 3 of our major competitors are all based in the Silicon Valley, and they filed their provisional US patent. However, because our patent was filed earlier, we could actually have some priority date even in the US through our UK application. I would say go UK first, but that's my perspective.
I guess I sold out. I went to the US first. Main reason for us was we're building a SaaS software business, and we have to look at who's going to acquire our business one day, who would we like to acquire our business one day. And for us, it's people like Microsoft, Google. It's the American juggernauts, and ultimately there's more value in that as we're scaling the business. To tell investors, but also tell ourselves that if we're going to sell out to these companies one day, they're going to value that in the US. So we went with the US strategy first. We've kind of sidestepped the UK, and no one's ever called us out on it, I guess, from an investor perspective. Maybe they've valued it more. We've not been criticized for that. I've just come back from a 2-week roadshow in China, and China is on an IP drive right now. They're trying to pull over UK companies or any company from outside China. And they ultimately were looking at how can we get your US IP over to China. We'll help you, we'll invest in you, so on and so forth. There was less talk about UK IP, and I don't know, it's just maybe on a global scale, people are looking at the big picture there.
Yeah.
Okay.
If I can just add on to that, any US IP is definitely more valued. I guess at an early stage, it's also a decision of cost and investment. UK filing does cost significantly less, especially when you don't have another US attorney involved and so on. So yeah, back to strategy, but on the longer term and on the exit strategy, the US is definitely still where the go-to really is, and China more recently.
Okay, any more questions? Lady there.
Just on that, I actually want to talk about trade secrets, but just on that last point, I think something that needs to be borne in mind, sorry, it's Julie Barrett-Major, also from AA Thornton, that actually you need to file, or at least get permission to file abroad from the UK IPO first, because there are rules concerning sending your UK secrets, as it were, to a foreign country before you've actually had that checked in the UK that there's not a security aspect. So I would strongly recommend that even if you're going to end up filing abroad, that you do so in the UK first. I just wanted to comment on the trade secret thing. I think there are 2 points that weren't raised around that, which need to be taken into consideration, especially if you're looking for worldwide or at least international venue for your business in the future and marketing and so forth. One is that with labour being so mobile these days, one of the risks of keeping trade secrets and not actually patenting is that your employees are likely to move elsewhere to your competitors, and they can't, even if they're honourable and they want to honour the secret that they've got with you, they can't unknow what they know, and therefore it's actually very difficult for that secret to be kept long term. So that's one of the problems. And the other problem with trade secrets is that many countries in the world simply don't have a trade secret law. So in India, for example, there isn't a well-developed trade secret law like there is in Europe. And therefore, if you actually try to enforce any trade secret rights, you will have great difficulty if you're doing it in relation to certain countries. So just 2 additional points to be borne in mind there.
Okay. Anyone want to pick up on that?
Yeah, I mean, you do need to know where you're marketing, where you're going to actually expand, and where your business is, you know. And this all goes back to an IP strategy. You need to know where your customers are, where you're going to sell, and make these decisions, you know, with full knowledge. Sometimes that's very difficult to do if you don't know where you're going to market in the future or where you're going to sell in the future. But it is, you know, just keeping that in mind and understanding, you know, where you're going. You know, it's like the U.S., your exit strategy is to sell to a U.S. company. You're definitely going to want U.S. protection. But knowing that, you know, at the beginning sometimes isn't. So, you know, looking at homegrown first and then expanding from there.
Okay. We've got a question over in the back.
Hi, Callum Smith, Barclays Bank. So Luke Ham in the slot before you talked about patent box, R&D tax credits and intangible assets. It strikes me that those are three topics very much in the domain of the accountancy profession. And it's a question really for Raj and Jordan, I guess. In the context of them being startups and building new businesses, were they advised by their accountants about the different options open to them from an IP perspective? And if not, are we missing a trick by not having the accountancy profession more aligned with IP advisory services?
Who wants to go first, Raj?
I could start on that. Yeah, I would say early on, it wasn't really our accountancy firm. We used like sort of a local accountancy unit, which I don't think gave us much advice, especially with regard to the IP. We were lucky enough, probably, to find an IP lawyer who sort of started out on his own startup business after 10 years on a very big IP law firm. And we could evaluate the sort of startup perspective of the IP, and eventually we started using KPMG for as our accountants, and they have a small business which does help you put IP on the balance sheet. So it helps you look at what have you spent on the intangible assets and sort of put it on the balance sheet, which does help in future investments or even an IP license or sales strategy. So I guess, yeah, a right accountant does know how to advise on the IP, but you would need the legal side of things with an IP attorney as well. Yeah.
I guess for me, I guess a little bit ditto. We're using KPMG small business as well, and yeah, I guess it's awareness. We've been told about R&D tax credits and patent box from pretty early on. We get spammed about 3 times a day on us. So I think it's hard to ignore it as an early stage company. I guess the point that's missing is the value of doing it so early on. That's the piece a lot of startups are miss on, particularly things like patent box. And the reason I'm separating the two out, because with R&D tax credits, it's pretty obvious what the benefit is. You've got cash flow or potential cash coming into the business. So that's something as a startup you'd really jump upon. But with patent box, it's perhaps been a little bit missed even with us. And despite me having my history, my knowledge, the people we've worked with, it's not really been well explained that we can put a value on investing time in doing patent box. So I think if there was perhaps more of a legal play with an accountancy firm, then that would be more advantageous to a company such as ours to take, to act upon it sooner than later.
Okay. Any other questions? We've got one from a lady there.
I'm a trademark attorney and a senior IP counsel at Philips Lighting. So I'd like to know, how do you value trademarks in your portfolio? Every time you launch a new service on the market, do you consider to protect like the name, the trademark? Have you registered the name of your company?
I could answer that. It's quite a, we learned about it the hard way, that we placed way too much importance on the patent filing instead of the trademark, which once we had a brand name sort of for the product, because we started out as a IoT consultancy firm, so we didn't really need a trademark except the company name. But eventually when we launched our own products and we had a name in the market which people would associate with, we even had a lot of press and media coverage behind the name. When suddenly we got a sort of a letter from the owner of Lupo, which was the particular trademark, because we filed with the trademark office and they notified, which they are required to do to the owner. And what we were building is, so Lupo rebranded as Zupo, which helped us sort of maintain some of the brand identity but still not infringe the particular trademark this person in London had. So he's a seller on Amazon who sells your sort of mobile cases. So the case you put on your iPhone or Android devices, that counts as class 9 of goods, which is mobile accessories. And we were in the same class and category because we were a wireless accessory to a mobile phone. Although we tried to defend that the two are not the same things. We are not selling phone cases, but it did not matter. So ultimately, we had to either pay a license to coexist within the name, or simply rebrand. And retrospectively, if we were to do this, we would have attended to this a much earlier. I think a lot of startups are guilty of not placing enough importance on the IP till you learn why it's important or why you should. So that was just our experience with trademarks.
I think at the opposite extreme, having had 100 years of history of our brand mark, IBM does tend to have a fair a degree of control over what it does with it.
I learned the easy way. Because I think of the whole Prada and the BMW stuff early on in the .com days, I learned to trademark early. And with Fan2, I went and trademarked pretty much before we even incorporated. And I found out in the US, the people that owned the domain fan2.com, it was a fan site for promoting sports. So I was thinking, how do I get it? How do I get the domain name now? Because I didn't have it. So wrote to them. It was not being used. It was just lying there dormant. Took about a year and a half to get their attention. Didn't play it hard. Didn't say we've got the trademark rights because it was a sports site. It has nothing to do with what we were doing. It was a different class altogether. Ultimately, they sold to us not because of any pressure. Where the trademark did benefit us was when it came down to Twitter. The Twitter handle was being used by somebody else, and we had other people using our since our IP. And Twitter released the handle back to us simply because we had the trademark. If we didn't have that, they would have probably said, "Sorry, we can't take it off somebody else." These were dormant, obviously, but it did help us. And I guess the company's tagline is "The future of work." We're focused on helping people in terms of how they work on a day-to-day basis. Gartner is actually using that at the trade shows. It's very common to their theme in the TMT business. And as I said earlier, we've not given them notice. We haven't sought out to defend IP because partly it's a question of is our pocket deep enough to defend our rights? Second of all, right now it's probably helping us. The word's getting out that the future of work is being used by a lot of other people. As the company scales, if we decide at some point now is the right time to defend our IP, we will go and do that at that point. But we are very much driven on protecting, I guess, trademarks, even down to looking at what our competitors are doing, what language are they using, and is that language common to what we're doing as a company? If it is, we will look at protecting that. So for example, one thing is, all your SaaS apps in one location. We're even looking at trademarking that at the moment, because if that allows us to protect the landscape of how you describe what we're doing as a company and what our competitors are doing, then that's something we're willing to do. And again, it's not very costly in the grand scheme of things to trademark compared to doing a patent, a utility patent.
Yeah, I mean, the Twitter thing's an interesting one. When I started on Twitter, I was an early adopter. I just went for @Wago, which was fine until there was a US pet care company that was called Wago, and I kept getting complaints about products sent through to me, which was slightly irritating. But any more questions?
Just say one thing.
Sorry.
Raj's experience with the trademark is something that we haven't really discussed so far, which is the freedom to operate. Is that if you are a tech startup, you should be ideally doing clearance searches for trademarks, brand names, and also your technology, your patent landscape. You should be doing a quick search because you don't want to stumble blindly into big problems and end up having to spend thousands of pounds rebranding and potentially losing all of that goodwill that you've built up over. If you don't get caught out quickly, you could have spent 10, 15 years building up goodwill in the name that you then you have to lose. And in the patent space, if you walk into someone else's patent landscape and their patent claims, you've either got a big claim to settle or you go back to square one. So freedom to operate and clearance searching is something that tech startups should be doing. It needn't be hugely expensive, depending on your definition of hugely, but it needn't be hugely expensive, and it can be staged, or it should be staged. before you spend £100,000 on multi-cavity tooling to create your product, you might want to spend £5,000 or £6,000 making sure you're actually going to be free to use that tooling, or that the product that falls out of that tooling has a value in the market that isn't going to be the value of a third party suing you. So it's worth checking freedom to operate early and updating that search as you go, because I've seen it a few times where people do an early search, go, oh, brilliant, we're free, and they plow on, but they subtly change almost everything about the product before it hits the market. And then when they launch, they've walked into a lot more problems. So you need to keep those searches updated. If you change anything, you should be updating that search.
Or even, they come up with the idea and then they do their research and develop the product, but then they don't launch until 2 years down the line, and they say, oh, well, I did the clearance search, but that was 2 years ago, And it's not just tech startups that have this problem, established companies do as well. It's one of those things that unfortunately get, overlooked, is brands, and oh, I got this great product, and, they get their patents all in place and they're all ready to launch. And you have a marketing person come up to you the day before their launch going, and this is the name, and you just kind of catch your breath going, okay, let's just hope it's free. And I've been in an industry where my marketing's done that, and it's cost us a lot of money to buy the rights the day before launch.
Yeah.
Okay.
Yeah.
Any more questions? I guess one of the things that I was going to kick off then was really just try and get your perspective. I mean, there's a huge amount in the press about AI. I'm not quite sure what percentage of stuff that is now labelled and put out there as an AI solution actually has AI. I mean, I have a very simple understanding of it. I mean, I think a huge amount of what's happening with AI is, frankly, misnamed because it's all about automating the world rather than trying to understand the world and react to it. I think people can get wrapped up and taken away by just tag names and things like that. I just wonder whether anybody has perspectives on, how you actually understand what is the reality behind, in some instances, the hype on new things that are coming through.
Could start on that. AI, to me, is how do you define? Is it artificial intelligence or augmented intelligence? And the way we see things, AI is going to be both fundamental and one of the most disruptive piece of tech probably in the next decade. But it would be augmented, not a replacement of human intelligence, so to say. A question is, how do you use AI to help both get the right information, data, and help process a lot of mundane or routine work that helps a company progress and make the key decisions around. So taking the example of, say, a piece of brand name, and it's really incredible how difficult it is these days to get a short, saying 4 or 5 letter name for, be it a bigger company or a startup. You need to have a domain name, you need to have the Twitter handles, a whole range of other social media accounts, for instance. You need to have a clearance on the trademark itself, and it's really, really difficult. So part of some of the software we have been building for our clients, most recently we have been looking at how can we automate more and more of this process. So we have actually developed a piece of AI tool which works on natural language processing. So straight away you kind of enter a brand name within this web app, and it returns you what are the trademarks have been filed similar, what names can be potentially infringed, so you have a freedom to operate opinion straight away from the software. It looks at what are the domain names that's available. So typically you would end up doing a manual search in a whole bunch of what's the cost to buy it out, and it lets you sort of consider all these decisions early on in one place. And I think just this little piece of software has helped us save maybe a few days worth of consultancy time, because it it augments what we do as a company. I think, and that's quite fundamental to AI. Don't think these are robots that are going to replace humans completely. At least we are not there yet. And the good thing is AI can be used to augment human work. So that's how we see AI.
Okay.
Okay. I guess for me, AI is definitely a word that's perhaps been blown up and become far too big compared to what it is today. I agree with Raj. I think it is very much right now in the phase of augmented solutions that add to the things that we may do on a day-to-day basis. In Fan2's case, it's about helping you with your information that you receive by prioritizing it, by surfacing it amongst the noise of what you're receiving on a day-to-day basis so that you can make more actionable decisions, if that's an email, if it's an IM, if it's any information you're receiving from SaaS. So it's very much augmented solutions. And I think as a early stage company, you are forced to provide, or you're forced to act upon things that you can actually sell, real market cases. That's what customers, investors are looking for. If it's too far ahead into the future, it's R&D, it's a PhD waiting to happen. And I guess when we just coming back from China again, we were being asked by many different provincial governments, are you a blockchain company? Are you an IoT company? Somebody forgot to say AI, so I corrected them. I said, we're an AI company. They said, yep, you're welcome as well. So it was very much the kind of buzzword of, if you're doing these top 3 things, we want to pull you over to China. We want to invest in you, want to give you offices, everything. We basically want to land you in China. So I think it's great, the potential, but you have to be realistic about where does it sit today as a technology, where are we in that journey? And I think that journey is very much today, that sense of augmenting what we do as in our tasks and activities to supplement and make it easier going forward. So I think that's my kind of take up on AI.
Okay. John?
Yeah, I think, there is a misunderstanding as to what it means. And as it's developing, it's like with anything, the dot-com boom, that was misunderstood when it first came out, and I think as, it progresses, the understanding will progress as well, and the innovation will come with it, and it will get to the point where, it will be, the artificial intelligence. But, at the moment, it is just augmenting what's already there. And building on that. And, I think it's an exciting space because there's so much of a future in it and there's so many things that we can do. But at the moment, because of the stigma around it and the misunderstanding around it, people are frightful and fearful of it as well. And I think that's something that needs to be addressed.
Just on that point, I think there's something about, if you're an early stage tech company and you're approaching investors, I think there's a sense of expectation from investors about the level of AI or the level of your tech. And I guess they can be a little bit misforgiven for the fact that there was this expectation in the investment community that AI, was the next big thing to invest in, and the payoffs are going to be huge. But I think that journey is still ahead of us. It's not something that's a 1 year or 2 year time frame. It's much longer, and hence why a lot of investors you'll find have a much more of an expectation from you in terms of what is the capability of your AI. And I think that's something that community just needs to somewhat balance right now in terms of the delivery of that. It's not a 1-2 year time frame. It's going to be much longer than that.
So, yeah, I guess picking up on that, one of the things that became quite apparent to me is, say, on the grounds that I can invent things but I can't write patents, quite often the patent attorneys have been very good at debunking some of the things that we've been putting forward as potentially being inventions. They have the ability to see through to the crux of an idea and actually make a decision as to whether it's novel or not. So again, I think there's a good partnership that can be had between the technical community and the patent community in terms of trying to understand what is the germ of an idea and how you can put these things together. Were there any more questions? I think we've probably got time for one more if anybody had a last question. No? Okay, so we'll just have a quick final thought from the panel just in terms of, starting off with the tagline, to patent or not to patent.
I think it's based on your strategy. You need to know what your outcome is. What are you trying to achieve? Do you want to sell? Do you want to stop your competitors? Do you want to just have a scare factor? What are you trying to achieve? What is your end goal? And you need to have that strategy and have a clear vision as to what you're trying to achieve, and then make the decision to patent or not to patent. And also not to forget that there's other IP available to you, and you need to use it as a full IP strategy and not just concentrate on patents.
Okay, Raj?
Yeah, I would say no matter the size of the company or the potential of a new invention, look at all 5 aspects of IP, from trademarks, patents, copyrights, sort of registered software, and as well as trade secrets. And all these should be part of the strategy. The issue is a lot of inventors as well as SME owners, including product managers from my experience in larger companies, simply do not look at IP. They want to ignore IP because they don't understand. And I think it was a very good point on the keynote that we need to change that. We need to make IP more understandable. Just as an example, if you're filing a patent, let's say a pulp with celluloid with special properties. I'm actually just describing how a patent attorney will describe a new invention like a piece of paper. It's a cellulose pulp with XYZ. We need to really do a better job of making that understandable across the ecosystem so investors understand it, the inventors as well as attorneys, everyone knows what to do with IP, and yeah, make it a little more simple. I think that's the, yeah.
And because I'm getting looks, we'll have 30 seconds each.
Okay. I think definitely you should be IP driven, particularly in that today, IP is now not just the traditional utility trademark. You've got to think about it socially. When you're getting your product out there from a marketing perspective, it's awareness, it's social awareness, and I think you have to protect that social awareness once you start to snowball and start to grow as a company. Okay. So definitely be IP driven.
And Alex?
Is IP important? Yes. Patent or not to patent depends on your strategy. I'll leave it there.
Okay, so I'll just do the final summary, which is that it looks like you've got to have a clear strategy, and it can be patent or not. Thank you very much.
Thank you. We are going to have a panel discussion on the IP regime in Cyprus, and that's going to be moderated by George Kapanelis. So if he wants to come up and... Thank you.
Thank you. How are you?
Thank you. Good morning. Hello.
Good morning. Please, great. Have a seat here. You have the microphone? You do? I don't have the microphone. Ah, you didn't have?
Oh.
I can shout. They will bridge you.
Have you all been mic'd up?
Excuse me. Ladies and gentlemen, good morning. My name is George Campanelas. I'm the Director General of Invest Cyprus. Invest Cyprus is the National Investment Promotion Agency of Cyprus, non-for-profit organization. Let me thank the organizers for this opportunity to present in front of this so esteemed audience the Cyprus new IP regime. It's my pleasure to have with us representatives from the tax and legal professional sector of Cyprus, as well from the industry. Mr. Kisley, co-founder and CEO of Wargaming, Mr. Kleathous, intellectual property attorney, and Mr. Alekos Pavalexandrou, who is a tax partner at Deloitte Cyprus. He has more than 20 years of experience in the fields of national and international tax planning and tax compliance issues, and he has been involved in a number of international corporate restructuring projects with extensive experience in tax due diligence and international tax planning projects. I call upon Alekos for his short presentation on the tax benefits of the Cyprus new IP regime. Alekos, the floor is yours.
George. I'm going to bore you with some technicalities, so allow me to use the podium. Okay. So, there are two eras when it comes to taxes in Cyprus and also in all other EU member states. We have the old IP regimes that cover pretty much every single IP, including trademarks, trade names, etc. And we have the new IP regimes going on in Europe, including Cyprus, that are restricted to some specific IP assets as well as specific R&D expenses. So the new IP regime of Cyprus, it sounds complicated, but it's not. Basically, what it allows you is an 80% tax exception of the qualifying profits from the exploitation of IP. It provides for a full tax exception when you are selling qualifying IP. You can amortize the cost of development or cost of acquisition of the IP over their useful economic life with a maximum of 20 years. Something new that we took it from the UK patent box regime is the embedded royalty income. So if you are using patents to develop a product, then part of the sales price of that product is considered to be an embedded royalty, so you are still entitled to certain tax exemptions. Now, how do you calculate that tax benefit, the tax exception? First of all, you need to look if your IP is a qualifying or not. And what is a qualifying IP? The most common is computer software, copyrighted computer software, or patents under the patents law of Cyprus. Certain other IP also qualify, like utility models or non-obvious, novel, etc. IP, but there are restrictions. Your gross revenue should not exceed 7.5 million per year, or if you are a group of companies, 50 million on a consolidated basis. The formula, you need to calculate your qualifying profits, which are calculated as qualifying expenditure plus uplift expenditure divided by overall expenditure, and you multiply that by your profit from the licensing of IP or the embedded royalty income. What is qualifying expenditure? It's R&D that the taxpayer carries out on its own, or R&D outsourced to third parties, non-related parties. The uplift expenditure is 30% of the qualifying expenditure, or the cost of acquisition of the IP, or R&D outsourced to related parties. And it's the lower of the two amounts. And you divide that by the overall expenditure, which is basically the qualifying plus the non-qualifying expenditure. So you do this calculation, you come up with a qualifying profit, you multiply that by 80%, and you get your deduction. Now, a company that does the R&D using its own resources or outsourcing to third parties, usually it will get the full 80% exception, which means that the effective tax rate in Cyprus will be reduced from 12.5%, that is our standard corporate rate, to somewhere around 2.5%. Okay. Okay. I have a detailed brochure outside on our booth if you want to visit and take more information, and we will answer questions at the end. Thank you.
Thank you, Alekos. Let's move to our next panelist, Mr. Marinos Kleathous. He's an intellectual property attorney with almost 15 years of experience and more lately a part-time lecturer at the University of Nicosia and the University of Central Lancashire in Cyprus. He has been recently appointed by the Ministerial Council of Cyprus as a member of the Cyprus Intellectual Property Law Committee. He is also a member of the Silicon Valley Law Association. I call upon Marinos for his short presentation on the legal frame of the IP regime.
Thank you, George. Thank you. And let me first say a warm thank you for this very interesting event. It's our very first participation, and it's a very interesting and useful conference, and we are looking forward to have the opportunity for networking and to get in touch with colleagues and brand owners who are interested for IP rights, and more specifically for IP rights in Cyprus. Now, I enjoy calling myself an IP activist rather than an IP lawyer, because I truly understand the importance and the beauty of the necessity of intellectual property rights. And it's a very sensible tool, it's a very big responsibility to defend and represent persons who invest the time, efforts, money to create new ideas and to make their ideas happen. So from our side, let me say that Cyprus, indeed, as a member of the European Union, has a complete legal framework and umbrella who protects generally the intellectual property rights. Also, due to our historical bonds with the common law system, the basis of the Cyprus IP law is, of course, the common law, and more specifically the UK legal system. Copyright, of course, which is mainly the tool that we use for the protection of software, is an automatic right. The basis is the UK copyright law and, of course, the current EU legislation. One other right is the designs, which is based on the EU design law. Trademarks, which even the forms that the government uses for the protection of a trademark in Cyprus are based on the UK system. But anyway, in February, we are going to have a new legislation, which according to the EU Intellectual Property Office, the new Cyprus trademark law will be an example for the remaining EU countries to adopt. And let me also say that the new system now, which will be implemented in Cyprus specifically for trademarks and designs, will give the opportunity for very fast procedures and not time-consuming. Electronically, even to conduct a search will be much easier and cheaper to do so. And the examiners were educated during the last weeks from the EU IPO authorities in order to be in line with the latest trends and the latest decisions of the current EU legislations. And also the patents, of course, which, although Cyprus is not an examining country, what Cyprus Patent Office do is to forward the applications, the patent applications, to the EPO, to the European Patent Office, and then it bases the decision of the national office is based on the EPO decision about the protection of a Cyprus patent. Trade secrets are also a very big and main area of protection, which of course are protected in Cyprus. So this is generally a general approach regarding the current legal framework. Let me say that there is expertise, that the Cyprus IP office, which is under the Registrar of Companies, is updated, they implemented new tools, they implemented new technologies and procedures in order to facilitate the whole IP law registrations. It's not only about tax. If we want to make Cyprus an innovation hub, it's not only about tax, it's also about the whole environment. And of course, the legal environment is a very important element. The education of the local society, of the startup community, is also another one important element that we use in order to attract, firstly, to encourage the local startup scene, and secondly, to attract foreign investors. And as a conclusion, let me say that as an IP lawyer, we understand that what we do is not only about money or business, it's mainly about culture. We are here because IP is very much related to culture, to communication, and to give the opportunity to the people to create new things and encourage, of course, the creativity. So we are very happy because the current framework gives this opportunity to the local entrepreneurship, but also to be a very useful option for any other is interested to come to our country for their business. Thank you, George.
Thanks. Our third panelist is Mr. Victor Kisley. He's the CEO and co-founder of Wargaming, one of the most successful and prestigious gaming companies. He's an award-winning online game developer and publisher. Founded in 1998, Wargaming has grown to become one of the leaders in the gaming industry with over 4.5 thousand employees and over 200 million players that enjoy its titles across all major gaming platforms. Their flagship products include the massively popular free-to-play hit World of Tanks, World of Warships, and World of Warplanes. The presence of wargaming in Cyprus and in Nicosia in particular contributed to the reshape of the city and the Cypriot economy in general. Wargaming is considered one of the flagship companies of the island, with one of the most prestigious buildings as well. We are aware that despite the fact that Mr. Kisley's offices are located in numerous and different locations, Mr. Kisley considers Nicosia and Cyprus as his base. So I will ask Mr. Kisley, what are the main reasons that you decided to choose Cyprus for your base, personally and business-wise, and what is your overall experience within the country?
Well, thank you very much for the introduction and this picture. Well, okay, around 2012, 2011, because we originated from Belarus, the business, and we had to go somewhere to do business internationally, right? EU would be the first choice. Cyprus, first of all, due to, let's say, cultural, religious, people's connections. So we just came to Cyprus. It was our first choice just to come to EU. After that, we did multiple attempts to research the rest of the EU countries and maybe some other jurisdictions. We consulted Deloitte all over the world, but it happened to be that Cyprus is the best for the kind of business we do. So today, we happen to be in Cyprus, not accidentally, but sometime for historical reasons. And now we are in full conscience in Cyprus and will stay in Cyprus till the end of time. If you do a kind of business what we do, which is developing software and selling software to end customers. Okay, we do end customers, the gamers. You may sell your software to businesses, right? Cyprus is the best in the world. You do have to have your headquarters in Cyprus, that's true. That's why we have this building, it's our HQ. We have like 300 people there with board of directors, myself, major shareholders live there in Cyprus. We live and work there, and I go to the 10th floor like every day, like it's work. We are taking major strategic decisions there. We have people who design our games, but this is, it may sound unexpected, but we really enjoy the full spectrum of life and work in this lovely island. So the IP regime, which gives you effective 2.5% corporate tax rate, has been described, and there will be brochure. The personal taxes actually are amazing too. For example, if you're expat, I mean, if you're not in Cyprus, like if you move to Cyprus and you earn more than 100,000, I believe, then you have 17.5% personal tax. Like, the best is only in Belarus, which is 12. Russia, 13. Okay, Dubai is 0, but it's really very hard. Then dividends, 0. Disposal of shares, 0. Okay, we're not disposing of any shares now, but 80 double taxation treaties with all around the world, which allows you to claim your tax base in Cyprus when you do it right, your IP usage, including United States, Australia, Japan, Korea, Belarus, Russia, Eastern Europe, everything. So there's there's not much to desire. And, you know, we have 4 million tourists coming to Cyprus every year for holiday. We live there. So, okay, we work in Nicosia, which is the administrative center. You have close proximity, obviously, to Deloitte Cyprus, to the Ministry of Finance, to the Prudential Palace. You know, from time to time, you have to go and drink a tea. But it takes you 40 minutes drive to Larnaca or to Limassol, or, okay, 1 hour to Limassol, Paphos 1.5, or Proteras to have a family holiday. Like, you can go quiet, family style, you can go party in Ayia Napa if you want, which I don't do, of course. And that's a paradise. Plus, it's very well connected through, you know, British Airways, Lufthansa, Austrian, Etihad, Emirates, pretty much East European airlines, like to major Russian, European, Central, West European cities. And through Dubai and Abu Dhabi and Doha, you go Tokyo, you go Singapore, you go Sydney. So it's really very well connected. Of course, more flights are always welcome, right? So that's what we do. You have to be, one last thing, you have to be really careful and disciplined in how you structure your operations, IP creation, etc. That's why Deloitte Cyprus and Christis is here, will help you, and if needs to be, he'll connect you to your, let's say, major market countries such as UK or US, Deloitte as well. So you have to make sure that decisions and the board of directors and operations and major kind of designs are happening there. The rest, you have the arm's length relationships with your own subsidiaries in wherever they are. We have it in Minsk, in Moscow, in St. Petersburg, in Chicago, in Singapore, in Sydney. You have disciplined arm's length with certain markup development agreements, which are very well documented and which reflect the reality. This is very important. There is no Mickey Mouse or hanky-panky, like you don't do this, right? And we have our selling offices or service offices, which again, use the IP, which the headquarter licenses to them, and they have certain markup and expenses for marketing, distribution, etc., etc. That's it. The revenue is consolidated in Cyprus with all those tax treaties. You have to be very careful with VAT calculation in Europe, all 28 countries. Okay, soon to be 27. Russia, Belarus, America, very careful, and GDPR, like make sure that you you don't violate the privacy laws. And you, of course, creative people, technical people, creativity, etc. You have to have, like in any business. The rest, Cyprus and Deloitte Cyprus is taking care of you.
Thank you, Victor. I believe that you covered the whole spectrum. So no questions to the rest panelists. I believe that since we have 5 to 6 minutes left, that it's a good opportunity to, if someone wants to ask something our panelists, either tax-related or legal-related, we'll be happy to take some questions. Yes, please. Can we have the microphone?
Well, the microphone. The food is really very good. You cannot go more Mediterranean than Cyprus.
Thanks. Hi, Victor. This is Sina from Fan2. So I just wanted to ask you, when you opened your company in Cyprus, what was the size of your organization at that point in time?
Around 1,500 to 2,000 people. So we relocated to Cyprus. We used to be in other jurisdictions, let's say, for historical reasons. Then we, again, with the help of Deloitte Cyprus, which helped us really professionally, we consolidated all of our main assets, including IP, relocating it from other jurisdictions into Cyprus.
And where was your company founded originally?
It was in Belarus.
Okay.
It's a former Soviet Union republic,
okay.
With various SPVs around the world, but they were not very, effective. That's why, it took us some time to bring everything to Cyprus. For example, if you are opening your company, if it's new, just the beginning, then go to Cyprus straight away. Like, like in any jurisdiction, taking your IP out of, let's say, Britain, it takes some, paperwork,
right.
and some movements.
Okay, thank you for that.
Some more questions? Yes, can we have the micro here, please? So what you're saying about the food?
Mediterranean, fresh. 3 harvests per year of cucumbers, tomatoes, and the likes.
And you can ski during the winter.
You have 1 week of downhill skiing on Mount Olympus, which is 2 kilometers. It's 2,000-meter mountain.
My name is Anna Hrustaleva, company by CAD, and I have a question for Victor about IP protection and about patent boxes. What are the best countries for IP registration and for patent boxes for your company? So you mentioned Minsk, Russia, Cyprus. Which are the best countries without where low taxation? What are the countries? Where do you apply patents?
No, patents is a separate thing from the utilization. So this is how it works. We create IP which belongs to a Cyprus company. This is important for the IP box tax regime. Then patenting, I mean, you patent in those territories where your IP will be used. Well, in general, so like US, it's, I mean, you can apply for a patent in any jurisdiction you want. If it needs to be in Japan, in America, in Russia, etc. So they're separate things. So the IP, when it's created, it belongs to a separate company. Then all forms of protection, you have to have patent lawyers, obviously, in these conferences, I bet about this. Then you register this for the sake, or patent it for the sake of, so nobody copies it, etc. So there are for us, there's 2 different things. Creation and the IP belongs. I mean, the intellectual property as created, the programs, the images, the movies, the like characters' names, they belong to the company. And then protecting, as long as you own them in Cyprus legitimately, then you protect them all around the world as situation requires. Am I correct?
Okay, just to add on IP box regimes from a tax perspective, the countries in Europe that has them is Cyprus, the UK, Luxembourg, Malta, and France, and recently Italy. Surprisingly, Ireland used to have it, but abolished it. Now, all these patent boxes regimes are being modified everywhere in Europe under the BEPS initiative, okay? So the Cyprus one and the Luxembourg one are now approved by the European Union, okay? So we don't expect any changes. And they are, comparatively, they are very similar.
Can I explain this very simple? Cyprus does not have any sandwiches, triple, double, Irish, Holland, etc. It's very straight. So, like I'm the direct owner of Wargaming, and we create IP. It belongs to. There's no BVIs, no second-hand kind of transfers. Everything is extremely transparent and simple in Cyprus. You don't have to do any sandwiches. Yeah. It works straight.
And nowadays, just to add, it's not easy to move IP from one country to another. There are exit taxes. So you need to get it right day one. Okay?
Yeah, especially Australia.
At this point, I would like to thank our panelists, and especially dear Victor, who took the time to join us today and express his love about Cyprus. I think it's very simple. It's tax and legal benefits for the companies, tax benefits for the employees. It's the location, it's the quality of life, it's the best of 2 worlds. So thank you very much for your attention. I would like to tell you that we have a booth outside, so we can continue the discussions with our panelists with further questions, and let's move to the coffee break.
Thank you.
Thank you.
Thank you. Amazing. Very good.
Now that we all want to immigrate to Cyprus, we'll take a networking coffee break and meet back here at 12.